3 weeks before financial close, the DFI's legal counsel issued a fatal defect notice. The share pledge in the SPV's constitutional documents triggered a restriction on enforcement. The DFI could not perfect the security as written. The shareholder agreement required unanimous consent to transfer shares, which meant the DFI could not step in on default without the defaulting sponsor's agreement. The direct agreement with the offtaker had not been executed. The transaction was paused for 4 months while the legal structure was rebuilt. The project finance was ultimately completed, but the delay cost the developer significant equity carrying costs and nearly caused the EPC contractor to invoke a force majeure clause for mobilization delay. The legal structure is not paperwork. It is the architecture that determines whether the entire transaction holds together at the moment of maximum stress.
Zara, this is the episode that most developers reach last, but should reach first. Most of the legal structure work should be initiated at the same time as the financial model and the offtake negotiation. Waiting until you have DFI interest before appointing legal counsel and designing the SPV structure means you will be rebuilding under time pressure during due diligence.
That is the correct framing. The legal structure is not something you design after the DFI commits. You design it before you approach the DFI, because the DFI's legal counsel will review it as the first step of legal due diligence. If they find structural defects, you are in rework mode during a period when you need to be in progress mode. Episode 12 covers the full legal structure: the SPV, the shareholder agreement, the project agreement suite, the security package, and the 7 legal mistakes that cause DFI transactions to fail at close. A special purpose vehicle, SPV, is a company created for the sole purpose of owning, developing, building, and operating a single infrastructure project. The SPV is the project company. It is the borrower on the DFI loan. It is the employer under the EPC contract. It is the seller under the offtake agreement. And it is the entity over which the DFI takes security. The SPV exists to ring-fence the project from the sponsor's other business activities. If the sponsor has 10 other projects and one of them fails, the failure of that other project cannot trigger a cross-default into the SPV's DFI loan. And if the SPV's project fails, the SPV's lenders cannot reach the sponsor's other assets, unless the sponsor has provided an explicit completion guarantee.
The bankruptcy remote structure is what makes project finance work. The DFI is not lending to the sponsor's balance sheet. It is lending to the project's cash flows, secured against the project's assets. This means the DFI's credit assessment focuses entirely on the project, its revenue, its costs, its contracts, and its risks. The sponsor's financial strength matters for equity injection certainty, but it is not the primary credit story. The project is the primary credit story.
The SPV has one more structural characteristic that matters for DFI transactions: cash flow control. All project revenues, from the offtake agreement, flow into SPV accounts that are subject to a charge in favor of the DFI. The accounts are structured in a waterfall. Revenues enter the revenue account, then flow through operating cost payments, then debt service payments into the debt service reserve account, then reserve account funding, then, if all tests are satisfied, distribution to sponsors. The DFI controls this flow. The sponsor cannot reach equity distributions until the DFI's requirements are fully satisfied. This account structure is a core feature of every DFI-financed infrastructure transaction. The choice of SPV jurisdiction is one of the most consequential structural decisions in the transaction. The primary consideration is DFI acceptance, a jurisdiction whose legal system provides reliable enforceability of security interests, whose courts are independent, and whose legal framework is familiar to DFI legal counsel. The second consideration is tax efficiency, specifically withholding tax on interest payments from the SPV to the DFI. A DFI lending to a project in a country with a 15% withholding tax on interest will require a structure that reduces or eliminates that withholding tax, typically through a holding company in a treaty jurisdiction, Mauritius being the most common in Africa.
The third consideration is security perfection. The jurisdiction must allow the DFI's security instruments to be created and registered against the project's assets under local law. A jurisdiction where share pledges are not recognised, where land mortgages cannot be registered in the project company's name, or where contract assignment is legally restricted, is a jurisdiction that creates a structural problem that cannot be fixed after the loan is signed.
For most African infrastructure transactions, the structure is a two-tier model. The sponsor holds shares in an offshore holding company, typically Mauritius or the Netherlands, for treaty benefits, and the holding company holds 100% of the shares of the Project SPV incorporated in the project country. The DFI takes a share pledge at both levels, a pledge over the holding company shares and a pledge over the SPV shares. The project assets, land, construction, offtake contract, O&M agreement, are all owned or contracted by the local SPV. The English law DFI loan agreement governs the lending relationship, while local law governs the security instruments over local assets. The SPV's corporate governance structure must be designed around DFI requirements from the start. The board of directors is typically 3 to 5 people. The majority sponsor nominates the majority of directors. The DFI may require an observer seat, a non-voting representative who attends board meetings. The quorum provision must ensure that no single shareholder can take unilateral action. A two-person quorum that requires at least one director from each principal shareholder class is standard. Reserved matters, the list of board decisions that require shareholder approval, must be carefully negotiated. Reserved matters that are too expansive create deadlock risk. Reserved matters that are too narrow give the majority sponsor unchecked authority.
The dividend and distribution policy is the provision that most directly affects sponsor returns, and it must be consistent with the DFI loan agreement's restricted payments covenant. The SJ cannot say that dividends are payable on a quarterly basis if the DFI loan says dividends can only be paid if the DSCR for the preceding 12 months was at least 1.2 times, and no event of default is continuing. The SHA's distribution provision must be subordinated to the DFI's restricted payments covenant, or the developer will find themselves in breach of the SHA when complying with the DFI loan, or in breach of the DFI loan when complying with the SHA.
The change of control provision in the SHA must specifically address DFI consent. The DFI loan agreement will require DFI written consent before any change in the ownership of the SPV or the holding company. The SAAA must reflect this, not just say that transfers require shareholder consent, but specifically state that any transfer requires DFI lender consent as a condition precedent. A SAA that is silent on DFI consent to share transfers creates ambiguity. At the moment the DFI most needs clarity, an enforcement event. Any provision in the SHA that restricts or delays the DFI's ability to enforce the share pledge is a provision that the DFI will require to be removed before financial close. The project agreement suite comprises 7 core contracts, all of which must be in final form, executed or substantially agreed, before the DFI will issue a term sheet. The first and most important is the offtake agreement, PPA, OSA, or concession. We covered this in Episode 9. The second is the EPC contract, lump sum turnkey, as covered in Episode 10. The third is the operations and maintenance agreement, a long-term contract with an O&M operator that specifies performance KPIs, mobilization obligations, the major maintenance reserve, and termination provisions. The DFI requires a direct agreement with the O&M operator for the same reason it requires one with the EPC contractor, to preserve its ability to step in if the developer defaults.
The fourth agreement is the land agreement, either a registered title deed, a long-term registered lease, or a documented surface rights arrangement. The DFI cannot take a mortgage over land that is not legally secured by the project company. A land lease that has not been registered is not security. It is a contractual right that may not be enforceable against third parties. The fifth is the Grid or Network Connection Agreement, which reserves the project's connection capacity and governs the technical interface with the transmission or distribution network. The sixth is the Fuel or Feedstock Supply Agreement for projects where the input commodity is separately contracted. And the seventh, which is often overlooked, is the Accounts Agreement, the arrangement between the SPV and the account banks that establishes the waterfall accounts and subjects them to the DFI's security charge.
The security package is the collection of legal instruments through which the DFI obtains recourse to the project's assets in the event of default. It has 6 components. The first is the share pledge, a pledge over 100% of the shares in the SPV granted by every shareholder. If the DFI enforces the share pledge, it takes control of the SPV and, through the SPV, every asset the SPV owns. The share pledge is the most powerful security instrument in the package. The second is the asset mortgage, a registered charge over the project land and all fixed assets attached to it. The mortgage must be registered with the relevant land authority under local law.
The third is the contract assignment, an assignment by the SPV to the DFI of all its rights under the offtake agreement, the EPC contract, the O&M agreement, and the insurance policies. This assignment places the DFI in the SPV's shoes. If the SPV defaults, the DFI can exercise the SPV's contractual rights directly. But the assignment only works if the counterparties have consented to it, which is why the direct agreement is a precondition of the contract assignment, not an optional add-on.
The fourth security instrument is the account charge, a charge over all the SPV's bank accounts, the revenue account, the debt service reserve account, the major maintenance reserve, and the construction disbursement account. The account charge means that the DFI can block or redirect cash flows in an event of default. The fifth is the insurance assignment. All insurance proceeds are assigned to the DFI, and the DFI is noted as loss payee on every policy. If a major construction defect triggers a car insurance claim, the insurer pays to the DFI, not to the SPV. The sixth instrument is the floating charge, a general charge over all present and future assets of the SPV. The floating charge catches any asset that falls outside the specific charges: new equipment, receivables, intellectual property. English law and most common law jurisdictions recognize the floating charge. In civil law jurisdictions, the equivalent mechanism must be specifically structured. DFIs impose 8 standard legal requirements that apply across all African infrastructure transactions. First, the loan agreement is governed by English law. English law is chosen because it is enforced by courts with international standing, because the financial contract terms, representations, covenants, events of default have well-established interpretations through decades of case law, and because English law judgments are recognized in most jurisdictions where the DFI lends. This does not mean the project agreements are governed by English law. The offtake agreement, for example, will often be governed by local law because the offtaker is a local entity, and local law governs the relationship.
Second, all security interests must be perfected under local law before the first drawdown. Perfection means registering the share pledge with the company registrar, registering the land mortgage with the land registry, and ensuring that the contract assignments and account charges are validly created under the applicable local law. Each of these registration processes takes time, often 4 to 8 weeks, and in some jurisdictions requires government approval. The developer who starts the security perfection process only after the term sheet is signed will almost certainly miss their target financial close date.
Third, no adverse pledge without DFI consent. The SPV cannot grant any security interest over its assets to any other party without the DFI's prior written consent. This prevents the sponsor from taking a second charge over the project assets to secure other obligations. Fourth, financial covenants, tested semi-annually. DSCR, LLCR, and leverage ratio must all remain within the DFI agreed thresholds throughout the loan life. A breach triggers a cure period, typically 60 days, during which the developer must remedy the breach. An uncured breach is an event of default. Fifth, information covenants, quarterly management accounts, annual audited financial statements, and immediate notice of any material default or event that could reasonably be expected to have a material adverse effect on the project. When more than one DFI or lender finances a project, the Intercreditor Agreement governs the relationship between them. The core principle is pari passu ranking. All senior lenders rank equally in their security rights and their recovery priority. No lender is first among equals. Voting on waivers and amendments is by majority of commitment, typically 66%, for routine matters, and by unanimity for material amendments to the loan terms. The standstill obligation prevents a minority lender from taking unilateral enforcement action during a defined standstill period, typically 120 days. A lender holding 5% of the loan cannot trigger enforcement and disruption for the entire transaction because it is impatient.
The facility agent and security trustee are critical appointments in a multi-lender transaction. The facility agent is the single point of contact between the lenders and the SPV. It receives financial information, distributes notices, and coordinates the lender's response to events. The security trustee holds the security on behalf of all lenders. The security trustee structure is particularly important in jurisdictions where individual lenders cannot hold security directly. Selecting a reputable facility agent and security trustee early, before the Intercreditor Agreement is negotiated, is part of the legal structure work, not an administrative formality.
The direct agreement and step-in right work together, and understanding their interaction is essential for structuring the security correctly. The direct agreement is a tripartite contract between the DFI, the SPV, and a key counterparty, the offtaker, the EPC contractor, or the O&M operator. In the direct agreement, the counterparty acknowledges the DFI's security assignment over the SPV's contract, agrees not to terminate the contract without giving the DFI prior notice and a cure period of typically 60 days, and agrees to novate the contract to the DFI's nominee if the DFI exercises its step-in right. Without the direct agreement, the DFI holds an assignment over a contract that the counterparty has no obligation to honor after a developer default. The security assignment is worthless without the direct agreement.
The step-in right is the DFI's right to substitute a replacement developer or operator into the SPV's position following a default. The 60-day cure period in the direct agreement gives the DFI time to find a replacement developer, execute a novation agreement, and ensure continuity of the project. The cure period is not a holiday from the developer's obligations. It is a window in which the DFI acts. Off-takers, EPC contractors, and O&M operators must consent to this in advance, in writing, in the direct agreement. Attempting to obtain counterparty consent to a direct agreement after a default event or during financial close under time pressure typically fails.
The distinction between common law and civil law jurisdictions is a practical structuring consideration that affects the availability of specific security instruments and the enforceability of DFI protections. Common law jurisdictions, Kenya, Ghana, Nigeria, South Africa, Zambia, follow the English legal tradition. The floating charge is available, the trust concept is recognized, so the security trustee works as designed. Step-in rights are established by case law precedent, and English law-governed loan agreements are well recognized and enforced. Most DFI transactions in Anglophone Africa are therefore straightforward in their legal structure, though each jurisdiction has its own statutory requirements that must be addressed.
Civil law jurisdictions, Côte d'Ivoire, Senegal, Cameroon, DRC, Mozambique, operate under OHADA in West and Central Africa and Portuguese civil law in Mozambique. These systems do not recognize the floating charge concept. There is no trust law equivalent, so the security trustee structure must be adapted, often using a parallel debt mechanism. Step-in rights are not established by case law and must be codified explicitly in the contract. DFIs lending into civil law jurisdictions always appoint local counsel with specific OHADA or civil code expertise, and the legal structuring cost and timeline are typically higher than in common law jurisdictions.
The loan agreement has 3 categories of legal obligation that the developer must understand before signing. Representations are statements of fact made by the borrower that are true at the date of signing. The SPV is duly incorporated. All project agreements are valid and enforceable. No litigation is pending. The financial statements are accurate. There has been no material adverse change in the project since the term sheet. If any representation is untrue at signing, the DFI can declare an immediate event of default. Representations are not aspirational statements. They are factual warranties with legal consequences.
Warranties are representations that are repeated, remade at each drawdown request and periodically throughout the loan life. The developer warrants at every drawdown that all project agreements remain valid, that the ESIA conditions are being complied with, that there is no pending regulatory action that would adversely affect the project, and that the financial statements provided to the DFI are accurate. A developer who submits a drawdown request when they know a project agreement has a material problem is making a false warranty, which is a separate and more serious event of default than the underlying problem itself.
Covenants are ongoing obligations for the life of the loan. Positive covenants require the developer to do things: maintain all required insurance, keep all permits valid, operate the project to industry standards, provide quarterly financial reports, and allow DFI inspection of project records. Negative covenants restrict the developer from doing things without DFI consent: taking on additional indebtedness, disposing of project assets, amending key project agreements, making payments to related parties above agreed thresholds, or initiating legal proceedings that could materially affect the project. The developer who reads the covenants carefully before signing will know exactly what requires DFI approval during the project's operational life. The legal conditions precedent to first drawdown are the specific legal deliverables that must be satisfied before the DFI releases any funds. 6 legal CPs appear in every transaction. First, all project agreements in final executed form, the offtake, EPC, O&M, land, connection, and accounts agreements must all be signed and delivered to DFI legal counsel for final review. The DFI will conduct a final document review at CP stage. Any late changes to project agreements at this point will require DFI legal re-review, which costs time. Second, security perfected: the share pledge registered with the company registrar, the land mortgage registered with the land registry, the contract assignments and account charges validly created.
Third, legal opinions delivered, local and offshore counsel opinions confirming the capacity, enforceability, perfection, governing law, regulatory, arbitration, and tax positions. A typical African infrastructure transaction requires at least 3 sets of legal opinions: one from DFI's own counsel, one from the developer's local counsel, and sometimes one from offshore counsel in the holding company jurisdiction. Fourth, direct agreements executed with every key counterparty. Fifth, corporate authorizations, board resolutions, and shareholder approvals for every transaction document. Sixth, financial close certificate from the independent engineer and DFI legal counsel confirming all CPs are satisfied in writing. Missing one CP delays first draw. Missing several means the financial close date passes without a drawdown, which triggers the commitment fee clock and sponsor equity carrying costs.
Legal opinions deserve specific attention because developers often underestimate the time required to obtain them. A legal opinion is a formal letter from a qualified law firm stating a specific legal conclusion, subject to identified assumptions and qualifications. 7 types of legal opinion are typically required in a DFI transaction. The capacity opinion confirms that the SPV and every signatory has the corporate capacity and authority to enter into the transaction documents. The enforceability opinion confirms that all transaction documents are valid, binding, and enforceable under applicable law. These two opinions are typically provided by local counsel, a law firm in the project country.
The security perfection opinion confirms that the security interests created by the security package are validly created and perfected under local law. This opinion is the most technically demanding for local counsel because it requires a detailed analysis of how each security instrument operates under local law and whether any perfection step remains outstanding. The governing law opinion, the regulatory opinion, the arbitration opinion, and the tax opinion each address a specific legal question that the DFI needs answered before it will lend. Legal counsel typically require 4 to 6 weeks to draft, negotiate, and finalize each opinion. In transactions with new counsel or unusual legal questions, 8 to 12 weeks is not unusual. The developer who commissions legal opinions at the same time as the term sheet is negotiated, not after it is signed, will meet their financial close date.
7 legal structuring mistakes cause DFI transactions to fail at close or require expensive restructuring. Mistake 1. A share transfer restriction in the SHA that requires unanimous shareholder consent to transfer shares. This means the defaulting developer must consent to the DFI's enforcement of its share pledge, which will not happen. The DFI will require this provision to be removed before financial close. If it is discovered at close, the SHA must be amended, which requires the consent of every shareholder. Mistake 2. Unperfected security. The DFI takes a charge over project assets, but the charge is not registered under local law. On default, the DFI holds an unregistered security interest, which may rank behind a subsequent creditor who registered first.
Mistake 3. Missing direct agreements. The DFI holds an assignment over the offtake agreement, but the offtaker never signed a direct agreement. The DFI's step-in right is contractually agreed with the SPV, but the offtaker is not bound. On default, the offtaker can terminate the PPA rather than continuing with the DFI's nominee. This single failure can destroy the entire security package for an energy project. Mistake 4. Wrong governing law for the loan agreement. Some developers are advised to use local law for the entire transaction for reasons of commercial nationalism or government preference. Local courts in many African jurisdictions do not have the expertise or independence to enforce complex project finance documentation reliably. The DFI will insist on English law for the loan agreement.
Mistake 5. A missing corporate authorization for one of the transaction documents, a board resolution or shareholder approval that was overlooked in the closing checklist. Legal counsel discovers this when compiling the CP certificate. The document must be re-executed by the board or shareholders, which requires convening a board meeting or obtaining written resolutions from shareholders across multiple time zones. This can delay close by 2 to 4 weeks. Mistake 6. Undisclosed holding company debt. The sponsor took a loan at the holding company level and secured it against the holdco's shares in the SPV without DFI knowledge. This creates an adverse pledge breach the moment the DFI takes its share pledge. And mistake 7. SPV constitutional documents that contain an automatic wind-up provision on insolvency. This means the SPV ceases to exist precisely when the DFI most needs it to continue operating as a going concern for enforcement purposes. Each infrastructure sector has specific legal considerations beyond the standard SPV structure. In energy, the generation license is a condition precedent to financial close, not to project development. A developer who applies for a generation license early in the project development process will be in a much stronger position at close than one who is waiting for the license when the DFI term sheet arrives. The grid connection agreement is also typically an infrastructure agreement with a state-owned utility, which creates the same sovereign immunity considerations as the offtake agreement, and may require a direct agreement with DFI consent provisions that the utility must specifically authorize at government level.
In transport PPP transactions, The concession agreement is the functional equivalent of the offtake agreement. The concession agreement is negotiated with a government body, a roads authority or transport ministry, and its terms govern revenue, maintenance obligations, and step-in rights for the entire project life. Concession agreements in transport are typically 40 to 50 years, significantly longer than the DFI loan tenor. The direct agreement with the roads authority must specifically address what happens to the concession on SPV default. Can the DFI step in, operate the toll road, and recover its loan? In many African jurisdictions, this requires specific government approval at cabinet or ministerial level. Approval that must be obtained well before financial close.
African Infrastructure Building Corporate Ltd, AIB Corp Ltd, is a specialist project development and advisory firm. Our advisory work on legal structure is grounded in practical DFI transaction experience. We understand what AFDB's legal counsel looks for in a security package, what IFC requires from a shareholder agreement, and how to navigate the perfection requirements in both common law and OHADA jurisdictions. We work alongside, not instead of, local legal counsel. Our role is to ensure the legal structure is designed to be DFI bankable from the start, so that local counsel is implementing a structure that works, rather than trying to fix a structure that was designed without DFI requirements in mind.
That distinction between designing DFI bankable and retrofitting DFI requirements onto an existing structure is exactly the right way to frame it. The developer who appoints legal counsel with DFI transaction experience from day one will spend less on legal fees overall than the developer who appoints general corporate counsel and then spends twice as long fixing structural defects in due diligence.
AIB Corp Ltd provides 4 legal structure advisory services. First, SPV structuring. We advise on jurisdiction selection, corporate governance design, and constitutional document requirements before local legal counsel is appointed, so that counsel is implementing a DFI bankable structure, not designing one from scratch. Second, Shareholder Agreement Advisory. We review SHA drafts against DFI requirements, step-in compliance, transfer restrictions, reserved matter scope, distribution provisions, and dispute resolution. Third, Security Package Design. We design the full security package, 6 instruments, and advise on the perfection timeline and local law requirements for each jurisdiction. Fourth, Legal Close Management. We manage all legal work streams from term sheet to first drawdown, coordinating legal opinions, direct agreements, corporate authorizations, and the CP satisfaction certificate.
Zara, the point about the direct agreement being a precondition to a valid security assignment rather than an optional add-on is something that really clarifies the whole security package concept. Without it, the DFI is holding a collection of legal documents that give it rights against the SPV, but no ability to exercise those rights against the people who actually control the project's revenue and assets.
Exactly. The security package has to be understood as a system. The share pledge gives the DFI control of the SPV. The contract assignments give the DFI the SPV's contractual rights. The direct agreements make those assignments enforceable against the counterparties. The account charges give the DFI control of the cash flows. Remove any one component, and the system has a gap, and the gap will be found, either during DFI legal due diligence or at the moment of enforcement.
The moment of enforcement is exactly the wrong time to find a gap. At that point, the project is in financial distress, the sponsor may be uncooperative, and the DFI is under time pressure to protect its loan. A security package that works cleanly in enforcement is built during the structuring phase, not assembled under pressure when the DFI has already sent a default notice.
And the same logic applies to the corporate authorizations and legal opinions. They seem like administrative steps at the end of the process, but each of them requires specific legal analysis, coordination across multiple parties, and time. A developer who treats financial close as a signing ceremony and not as a legal delivery process will always be surprised by how much work remains in the final weeks. That is Episode 12, the Infrastructure SPV and Legal Structure for African Infrastructure. special purpose vehicle design, jurisdiction selection, shareholder agreement key provisions. The 7 Agreement Project Agreement Suite. The 6 Instrument Security Package, DFI Legal Requirements, the Intercreditor Agreement for multi-lender transactions, step-in rights and direct agreements, common law versus civil law, representations, warranties, and covenants, legal conditions precedent, and 7 legal structuring mistakes that cause DFI transactions to fail at close. If you found this episode valuable, subscribe to the channel. AIB Corp Ltd publishes a new episode every week on building bankable African infrastructure projects.
Share this episode with developers who are about to appoint legal counsel for an infrastructure project. The structuring decisions in this episode are ones that legal counsel must implement, but the developer needs to understand them first.
If you are structuring an SPV for an African infrastructure project, selecting a jurisdiction, negotiating a shareholder agreement, or designing the security package, AIB Corp Ltd can support you. SPV structuring, SHA advisory, security package design, and legal close management, all on a retainer and success fee basis aligned to African project budgets.
Visit www.AIBcorpltd.com or contact the team at projects@afroglobaltrade.com. Initial consultation is confidential.
Episode 13 covers financial close, the final steps: signing, first drawdown, construction commencement, and DFI monitoring through the construction period. If you have worked through episodes 7 through 12 and have the financial model, ESEA, offtake, EPC contract, DFI engagement, and legal structure all in place, episode 13 shows you how the transaction closes and construction begins.
The last mile. Do not miss it.
Subscribe. Leave a comment with your question or the specific legal challenge you are facing on your project, and share the episode with one African infrastructure developer who is approaching financial close.
AIB Corp Ltd, African Infrastructure Building Corporate Limited. See you in episode 13.
www.aibcorpltd.com.
Financial close is the goal. The legal structure is how you get there.
Episode 13, the final steps.